Hello, friends. My name is Ismael and I'm the principal immigration attorney at I.S.Law Firm. I apologize for the delay in starting this video for those who have been waiting. So today I will briefly talk about family reunification, the petitions for spouses, children, and parents, whether inside the United States or outside of the United States. I also want to provide an update about the Title 42, which is ending today. That's for asylum applicants at the border, for those who arrive in the United States border with the Mexico southern border and apply for asylum for entry into the United States. And then I will answer as many questions as I can, which you can post on the top, on the chat section of this video. And if you view this video after the live session is over, it will be posted as a recording and you can post your questions in the comment section and I will again try to answer as much as I can. So let's start. Please, I ask if you can like this video and subscribe to our channel. We'll greatly appreciate this. Okay, so regarding the I'll start with the family reunification process. So regarding the marriage-based cases or cases sponsoring U.S. citizens sponsoring their parents who are outside of the United States, the process consists of filing a petition with the United States Citizenship and Immigration Services. And then once the USCIS reviews and approves the petition, they send the case to the State Department. Which will be the second stage of the process. So the process consists of three stages. The first is the petition here in the United States. And once the USCIS approves that petition, they forward it to the State Department for further processing. Then the State Department will contact the petitioner and the attorney of record, if you use the attorney for the process, for additional forms and documents. Once all of those forms and documents are provided and submitted to the State Department National Visa Center, they will forward the case to the U.S. consulate in the country of residence of the beneficiary, which is either your parent or spouse or child under 21. Now, under the family reunification, in the family reunification process, there are several categories. Categories are either immediate relatives, which includes the spouses, wife or husband, or children under 21, unmarried, and parents of U.S. citizens. Only U.S. citizens can sponsor their parents' immigration into the United States. The lawful permanent residents can sponsor their spouses and children, but they cannot sponsor their parents. They will have to first file for citizenship, become U.S. citizens, and then they'll be able to sponsor their parents. Now, again, I see more people are joining. Thank you very much. I will talk about the family reunification, which I already started. Then I will provide an update about Title 42, which is which was the rule, the law that was used by the Trump administration and then continued under the Biden administration, restricting entry into the United States through southern border. So I'll provide an update as to the border processing, and I will answer as many questions as you may have. You can post any questions related to immigration law. It doesn't necessarily have to be related to these topics. You can post in the chat section, and I will answer as much as I can. So on family reunification process, I'm often asked how long it takes to bring either a spouse or child or parent into the United States. Typically, the entire process takes anywhere between 12 to 18 months, which is about 1 year to 1.5 years. However, if there are any emergency circumstances, then the case can be expedited potentially. So you can request an expedited review at all of these three stages. Number one is the USCIS, number two is the State Department processing, and number three is the consular processing. So you can also request to expedite directly to the consulate, and the consulates have a power to take the case directly without circumventing the National Visa Center, without National Visa Center processing. So the important parts of the family reunification process that you have to pay attention to is, obviously preparation of the forms that are being filed. If you make any mistakes, then the process gets delayed significantly more because of the request for additional evidence being issued either by the USCIS or the State Department. But the other important what you need to pay attention to, the important part, is preparation of the documents in support. And in many countries, we notice some clients have issues about getting their civil documents. So if your immediate family member is outside of the United States and you're sponsoring their immigration, it's best to start planning how they're going to, renewing whatever documents they may have expired, or obtaining documents they may have not had before. For example, in some countries, people don't have birth certificates. So there is a process through which they can get birth certificates, specifically long form birth certificates. There may be marriage certificates missing, or some other documents, or somebody may not have current passport. So it's best to start renewing all of those documents beforehand. Now, one of the important nuances in the consular processing case is that for immigrant visas is that the beneficiary will need to provide certificate, police clearance certificate, confirming that they didn't have any convictions or records of any criminal records from the countries where they lived after 16 years old for at least 6 months. And that's the important nuance, is that it's not only the police clearance certificate from the country of their residency, but it's also the country where they have resided at one point in their lives after they turned 16. And sometimes it's really difficult process to obtain those records, to obtain the police clearance certificates. So it's best to plan ahead so that you don't have to, you lose more time after the petition is approved and you're trying to provide those documents to the NVC and the consulate. You want to make sure that you have everything planned, you know how to obtain and where to obtain those documents. Now, I'm often asked, should I prepare all of those civil documents for the consular visa processing beforehand, before the actual petition is approved by the USCIS? And the answer is no, don't do it yet, because in most of the countries, those documents have expiration dates. But do check the expiration dates when the police clearance, for example, certificate will expire. And then if you have, if it's a significant amount of time, if it's 1 year validity of that document, for example, then you may want to start doing that while your I-130 petition is still pending. So I also wanted to talk about the diversity visa processing in U.S. consulates abroad. As we all know, recently, just several days ago, the results of the diversity visa, which is also known as a green card lottery, came out, and there are many winners that contact us, whether they're abroad or they're inside the United States. And some of them are not sure about the next steps, what needs to be done. They read information online and they're not sure what needs to be done. So for those individuals who are outside of the United States, the first step you need to file is the DS-260 with the State Department. You can look it up online and find the link to the State Department's website to be able to fill out those application forms and file. If you need professional help, which is strongly advised, then you should contact immigration lawyer, you should contact our law firm, and you have the contact information in the chat section, which will be also in the comment section below once this video is posted. So the first step is to file the DS-260 for you and all your family members. Next, the Kentucky Consular Center, which is part of the State Department, will eventually send you an email asking for those civil documents and additional documents. So, and that process, when the Kentucky Consular Center is going to contact you, is going to be sometime after October of this year. So if you were selected for diversity visa lottery this year, meaning you found out just recently, several days ago, that means you were selected for 2024. And the processing of those diversity visa winners cases will start from October 1st of this year. That's the start date for the fiscal year of the U.S. federal government. So if you are inside the United States and you've been selected through the diversity visa lottery process for further processing, then you will be able to file for adjustment of status in the United States. Now, again, the time when you can file for adjustment of status is going to start from October 1st, but there is a line, and based on the selection notice number that you have, if you look at your selection notice that which tells you that you won this in the green card lottery, then you will see the number, and based on that number, that's the place in the queue for your adjustment of status application or the visa interview at the U.S. consulate. So based on that number, looking at the visa bulletin that is published by the State Department, you will know when approximately you might be contacted for an interview, or if you're inside the U.S., when you will be able to file for adjustment of status in the U.S. Now, some of the winners of the diversity visa lottery are inside the United States, but they don't have a current valid lawful status in the U.S. Those individuals may not be able to apply for adjustment of status in the U.S. with very narrow exceptions. Most of them will not be able to apply for adjustment of status for their green cards inside the U.S. They'll have to leave the U.S. But there are also intricacies if you are been in the U.S. for more than 6 months unlawfully, or for more than 1 year unlawfully, then you may incur 3-year or 10-year ban upon departure from the U.S. So it's very important to consult with a qualified, licensed immigration attorney about your chances of obtaining your permanent residency based on the diversity visa if you are inside the U.S. And if you are inside the U.S. currently in a lawful non-immigrant status, you also have to maintain that status until the time comes for you to apply for adjustment of status. So this is all about the diversity visa process. We just recently, the State Department announced recently the results of the diversity visa lottery, and for all the winners, congratulations. But it doesn't end here, so there are lots of steps to take. Again, please consult with us or with any other immigration attorney who is experienced and licensed to handle these types of cases. We'll be happy to help. So next, I'm going to talk about the Title 42. You probably hear this in the news. What is Title 42? How does that affect or can potentially affect your immigration chances into the United States? Or what is all this is about? Again, please, if you have any questions, please post your questions in the chat section. I do see some questions already posted, but I will answer all of the questions posted in the chat section as the time permits. And if you have questions after this video this live stream is over, you can still post it in the comment section, and we will answer as much as we can. So Title 42 was a law that was used by Trump administration to in efforts to limit the number of non-citizens, foreign nationals entering the United States through southern border. Title 42 is part of the U.S. law, which says that, during the emergency or some kind of pandemic, the federal government can stop processing immigrants at the U.S. borders, specifically, immigrants that can potentially pose threats to the U.S. because of the current ongoing pandemic. So at that time, Trump administration decided that they will no longer consider asylum applicants. And at the U.S. border, the officers can turn around all asylum applicants without considering their applications. There's been a lot of criticism of Title 42 because, as we all know, Trump administration was, very positioned very anti-immigrant, and they were, trying to utilize every possible tools and laws to limit immigration into the United States. And there's been a lot of criticism that Trump administration was just, using the pandemic as a pretext to, turn around poor, asylum applicants at the U.S. border without following the rule of law, which requires to process them to see if they really qualify for asylum or not. So during the Biden administration, once when President Biden became president, they tried to stop this Title 42. They issued an executive order. President Biden issued an executive order trying to stop this, but the Republican states filed a lawsuit in federal courts, and the U.S. Supreme Court put a pause on the stop of Title 42 application, meaning the order was issued to Biden administration to continue turning around the potential asylum applicants at the U.S. border. Then eventually, Biden administration continued doing that, but it was very inconsistent in some of the checkpoints. Asylum applicants could be processed, they could enter the United States. We have had many clients who told us that they went from checkpoint to checkpoint trying to affirmatively arrive at the checkpoint and apply for asylum or request protection, and they were turned around from several checkpoints. Some of them tried 4 or 5 times, and then eventually one of the officers allowed them into the U.S., processed them. Most of them were detained at that time. So the end date for the Title 42 was May 11th, today, which is the official end date of the pandemic emergency in the United States. So the Title 42 now ended officially today. What it means for any potential asylum applicants at the U.S. border, southern border, is that all of them by law have to be processed. They have to be allowed to tell their asylum story or declare that they are requesting protection in the United States. Now, as it's understandable, we expect significant flow of migrants from the southern border because of this Title 42 now ending, and the Biden administration is working hard to prepare for processing of those migrants. They don't have enough, obviously, officers or detention centers to detain all of the applicants. But one of the things that the Biden administration came up with recently to kind of reduce the stress and pressure on the border is that they have came up with an app that can be downloaded once the foreign national is in Mexico. They can download the app, which is called CBP One, through which they can register with the Customs and Border Patrol officer, with the CBP, and they can register an appointment with the officer. They can come to the border, provide information about them. Then the CBP officers will conduct some background search, some vetting, and then eventually they will be allowed to enter the U.S. And that has been working for several months now. It's been working very successfully. There is no detention once the applicants download the app, CBP One app, on their phones in Mexico. It cannot be downloaded while you are in a third country. You have to be physically located in Mexico to be able to download this app and to use this app. But it significantly reduced dangerous conditions at the border when individuals were trying to either swim through the Rio Grande or walk through the deserts or jump over the fences. There have been lots of migrants who suffered, and some of them died during that process. So that's why the CBP One is a much humane and simpler way or secure way for migrants to come and apply for asylum in the United States. Now, there is a lot of criticism from Republicans in the Congress on this CBP One, because they're saying this basically means that our borders are open for everyone. Part of it is true that it's very easy, it's simple for anyone to use that CBP One app, but it's not. I wouldn't attribute this problem to the idea of having this app and system. I would more attribute it to the officers not maybe conducting a thorough background search or thoroughly investigating who this person is before letting them in. I mean, I do get some stories from clients. They're just basically saying that we had this app, we made the appointment, the officer just said good morning, looked at our documents, and let us in without any visa or without even asking questions. are you here to apply for asylum or not? But once these foreign nationals are allowed to enter the United States through the southern border, they're not just let loose. They are being tracked. They're forced to have an appointment with the Immigration and Customs Enforcement to check in. They have to provide the updates about their location, and they are being issued a notice to appear immediately. The notice to appear is issued immediately, but the appearance itself is not. But the notice to appear in immigration court for the removal proceedings. And during these removal proceedings in immigration courts, those applicants can apply for asylum and request protection, and the immigration judge will listen to their story and make a decision about their case. So the system is there, the system exists, the problems in the system also exist. For example, these notices to appear indicate a certain date when the foreign national has to appear in immigration court, but the immigration courts don't have the file yet, and they don't open the immigration removal proceedings yet. And a lot of times these immigrants, they don't know where to go or what to do with it. And then immigration courts are significantly delayed. Now they've improved, they have got new judges, they hired more judges, they now processing cases faster, but of course it's not ideal, but there is a lot of improvement, a lot of room for improvement. So with that being said, again, I will answer as many questions as I can. If you have any questions, anything related to immigration law, you can post it in the chat section. I will answer as much as I can before I hang up. And please also press like and subscribe to our channel. Okay, so the first question I have is Yarka Sanadka Cusub is asking, hi, do you work in just one state or you have offices in all over the country like California? So that's a very good question. So we work in all of the United States, and we also work in many other countries. Now, as you all know, the work that is now currently being done, just as you're seeing me online through your smartphone or computer, so all of the work of immigration lawyers is done usually online and remotely. Even individual and master hearings in immigration courts and client interviews at USCIS asylum offices or field offices are done remotely most of the time. So there is no need to limit yourself to a lawyer that is close to you physically. So you should choose the lawyer based on their experience, skills, how comfortable you feel with this lawyer, and how much you think they will increase the chances of getting approval in your case. So no, the answer is no. We don't have offices in all of the 50 states, but we work with all 50 states, and I have probably appeared in almost every immigration court in the United States. So if you are looking for an immigration attorney, we'll be happy to help you, or you can shop around. Again, don't limit yourself to only your state or locality. All right, the next question is, hello, sir. I recently became a U.S. citizen, but I have to go back to my native country to take care of my family, and I know I won't come back. What should I do? I am from Italy. It's up to you if you want to renounce the U.S. citizenship, but you don't have to. So once you're a U.S. citizen, and I do get this frequently, this question, but once you're a U.S. citizen, there is nothing forcing you to live permanently in the United States. It's not like permanent residency. Once you have permanent residency, your green card, you have to permanently live in the U.S. You can travel temporarily for whatever business you have or family issues you have. But if you stay too long outside of the U.S., you may potentially lose your permanent residency unless you file for what's called a re-entry permit. You can apply for re-entry permit beforehand to get a permission to be absent for up to 2 years, and nobody will question you the length of your absence. They can still question you for the purpose of the absence, but not for about the length of the absence. So you're not going to have troubles traveling back and forth into the United States. So for permanent residents, you have to maintain your permanent residency in the U.S. You have to maintain close ties to the United States. But once you become a U.S. citizen, you're a free bird. You can go and live anywhere you want, and you can come back to U.S. and not come back as long as you maintain, obviously, your allegiance to the United States. You're not violating the U.S. laws, but it's up to you. You can remain a U.S. citizen, or If you don't want it, it's up to you. You can renounce the U.S. citizenship. I have never had a client who did that, but there is a process on doing that. Okay, next question is, hello, Ismael, can C1D holder apply for asylum? Yes, so C1D is a crewman's visa. So individuals who work, for example, on cruise ships, and they come aboard, and then the cruise ship docks here in the United States, then the crew member can jump off or just walk out and with that visa, and then or then they can ask for asylum. Or a C1D can be somebody who is coming to the US, for example, flying to the United States so that they can board a cruise ship or any kind of vessel in the US so they can work as crewmen for that vessel. And in the process of doing so, obviously, they are inside the US and they can apply for asylum in the US. But the short answer regarding asylum, everybody should know that anyone can apply for asylum. No matter how you entered the US, no matter how you ended up in the US, no matter what is your status, if you have a status, if you had a visa, if you don't have a visa, even if you have a permanent residence in the US, even if you have a green card, you can apply for asylum, because green card does not provide the protections that the asylum the asylum provides. For example, with a green card, you don't get a travel document, which is a substitute of your passport. With a green card, all you have is just a permission to live permanently in the US. But once you have asylum, the United States affirmatively is providing protection to you, and the United States provides a travel document which substitutes your passport, which tells the countries, the other countries in the world, that this person is under our protection as a refugee, and they're traveling abroad to a third country as a US refugee rather than citizen of that country from which you got asylum. So again, the short answer is yes, anyone can apply for asylum. You can apply for asylum even if you have crewman's, you entered the US with a crewman's visa or with no visa. The next question is, Willy Carrera is asking, I am a green card holder, but I am overstaying here in the Philippines. How can I return in the US? It depends on many factors. How long you overstayed in Philippines, what was the reason you overstayed in Philippines, what are the ties you have to the US? Do you have a family in the US? Do you have a property? Do you have, things that connect you to the United States? Using all these factors, then you can argue that you never abandoned your permanent residency in the United States. But again, it's hard to answer the question about, if you overstayed in Philippines or any other country and you're a permanent resident, without knowing all of the details of your case. Again, the factors are, how long you overstayed, what was the reason why you overstayed? Was there some kind of emergency or family situation? Or was it related to the pandemic? And then, what kind of ties to the U.S. you have? There is a misperception that if you're a green card holder and you're outside of the U.S. for more than 6 months, you automatically lose your permanent residency. Or if you have been outside of the U.S. for more than 1 year, you automatically lose your permanent residency. That's not true. You don't. You still have an argument. You still have a chance. And by law, you do have a chance. Even if you stay outside of the U.S. for 5 years, 6 years, 10 years, you can still return to the U.S. with your green card, and you will be stopped at the border. They will ask you questions. Most likely they'll take away your green card, but they have to allow you to enter the U.S. because the Customs and Border Patrol officer doesn't have a power to deprive you of permanent residency. Only you can voluntarily give it up, or immigration judge can deprive you of permanent residency. So the officer at the border must allow you enter the U.S., but they'll give you notice to appear in immigration court, where you will be given a chance to prove these things that I just talked about. Your close ties to the U.S. You never intended to permanently abandon you never intended to abandon your permanent residence in the U.S., and that you may have had some, emergency reasons or pandemic-related reasons or family reasons why you were absent for so long. Okay. Next question is, Melisa Cate is asking, can I file asylum if I am F1 student now, yes, you can file for asylum if you're on F1. As I said, anybody can apply for asylum, but being on a valid status such as F1, on a current non-immigrant lawful status, it also helps you to avoid the 1-year deadline. As many of you know, for apply for asylum, you have to file your asylum application within 1 calendar year of your entry into the United States. The sooner the better, but the strict deadline is 1 year. But there are exceptions to this rule. And one of those exceptions is if you had maintained your lawful non-immigrant status, such as, for example, a student status, then that 1-year deadline is tolled until after your status ends. So, for example, if you've been in the US for 3 years as a student on F1 status and you never violated this status, you maintained it, and then your program is ending, or your OPT's, optional practical training, is ending, so you're about to lose your F1 status, then it's best to apply for asylum at that time. Now, even after expiration of your current status, you can still apply for asylum, but the law says that you have to do it within reasonable amount of time. And that has been interpreted by the Board of Immigration Appeals to mean 6 months from the date of expiration of your status. So again, to give a practical example, you're on F1, you've been here 3 years or more, or whatever many years it took you to graduate, and you graduated, you're about to lose your status, you didn't find a job with OPT, or you didn't have OPT, and then now your status is about to end, you want to apply for asylum. You can do so. You can also do so while maintaining your status, meaning your status doesn't have to end. You can still have your F1 and you can apply for asylum while you're maintaining your status, which is a better option because it also gives you additional protection in case if your asylum is not approved, you don't get the risk of being ordered removed from the United States, a removal order, which would ban you for 10 years. Then you have to appeal, and the chances of getting the asylum decision, I'm not saying it's very low. We have done many times, but it's it becomes harder and harder. But if you're on F1 and you maintain your status and you file for asylum, and your asylum application is, let's say, it's pending for years, and you find a job, an employer who's willing to sponsor you for permanent residency, as long as you maintained your status, then you have a green light to be able to adjust your status to permanent residency based on employment. Or if you win, you get selected through diversity visa lottery. Again, maintaining your F1 status while your asylum case is pending, it's a good idea. But of course, it's expensive. If you're paying your tuition expenses and you have to study, you have to maintain the status, then that might be costly. All right, the next from the same individual wrote, telling stories why your asylum is going to happen to anyone who will apply asylum as from May 11, 2023. I did not understand the question. I apologize. Let me read again. Telling stories why you asylum is going to happen to anyone who will apply asylum as from May 11, 2023. Again, I have no idea what this question means. If somebody understood what this question is from Melisa Cate, please let me know, or Melissa, if you can please rephrase this question, I'll be happy to answer. The next question is, hello, how long does it take to get a family-sponsored visa? So this is a broad question because, as I said, the family-sponsored visa consists of many categories. There is immediate family members, which is spouses or children under 21 or parents of U.S. citizens, and that takes about 12 to 18 months processing. But for anybody else, it depends on the category. For example, children above 21 years old or married, it can take anywhere 4 to 6 years of processing. Spouses of permanent residents takes about 2 years or more. The siblings of U.S. citizens, brothers and sisters, takes about 16 years or more. And that's not because of the processing delays, it's because of the limited number of green cards available for siblings of U.S. citizens per year based on the law, and there is no expedite process for that. So I often get asked by U.S. citizens if I can bring a sister or brother. In practical terms, you cannot, because it's going to take about 16 years or so. But the process exists. All right. So the next question is, hello, Sus. Good day. Hello. Okay. Next question is, Susan is asking, we filed an I-134 on behalf of a Haitian lady, but there was an error on her date of birth on the application. We have tried and tried to get that fixed, but nothing has happened in months. So but nothing has happened in months, so she cannot her travel permission for humanitarian parole. How can we get this fixed? Now, you filed I-134 on behalf of the date of birth, so that's probably refers to the new program, the humanitarian parole program. That's I-134A. There is no legal representation in this process. So as such, I haven't dealt with I-134As myself for the clients. But from what I know, there is instruction on how to contact the USCIS for any issues. But, I see that you tried to get that fixed, but nothing happened for months. So, to be honest, I don't know. I don't have a specific method of doing that now, but that can be, I don't know, maybe you can write to senators, congressmen, or something, and then try to push it through other channels. But there is no specific channel that I can tell you do this and this will be fixed, especially for the I-134As, which is, again, it's a humanitarian parole program. Many of you probably heard of it, for Venezuelan citizens, for Ukrainians, for Haitians. There is this program where a U.S. sponsor can file it and bring them here. I don't know if you tried to file a new I-134A. Maybe that could be another solution, to file it again, especially since the date of birth was different. That might help, to not make it look like as a duplicate. All right, next question is, hello there, how long to get asylum decision? Thank you. So this question is broad because there are different ways of getting asylum. One is through immigration court, and one is affirmative asylum, applying through USCIS. It also depends on many other factors, such as judge, the court, the location of the immigration court, or the location of the asylum office. So generally, the asylum offices are very I would say chaotic in scheduling interviews, but generally they're looking currently at about 2016. So the cases that we filed in 2016 are getting scheduled for interviews through asylum offices. That makes it about 7 years of processing. Now, some of the cases we file sometimes get scheduled much faster, even without an expedite request. But in terms of immigration court cases, the asylum depends on the judge's calendar. So it used to be years, but now they hired a lot of judges, and the cases are being processed faster, relatively faster. And some judges schedule their individual hearings, which is the main hearing, trials. They schedule 6 months into the future, but some judges schedule their hearings in 4 years from the date of the initial hearing, which is a master hearing. So there is no way to predict or give you specific timeline. Next question, is it possible to apply EB3 visa jobs from Kenya through your law firm? Give contacts. Yes, our law firm handles EB3 immigration cases as well. EB3 means employment-based 3, category 3. That's for workers who have U.S. employer who is willing to sponsor them for permanent jobs, for permanent residency, and that employer can file, go through the Department of Labor, file labor certification, then go through the USCIS, file a petition, and then the beneficiary employee can be processed through State Department consular processing for their permanent residency in the U.S. Now, can we handle this as immigration law firm? Yes, we can. Can we find you an employer? No, we are not. We don't find employers for potential workers abroad.
For that, you can probably contact staffing agencies and so on. So the first thing, if you are planning to move to the United States through employment-based category EB3, is to find a real employer in the US who's willing to participate in the process and sponsor you to the US. It's very hard because the process takes about 2 years, and during that time you're stuck there and they are here, unless you get some kind of H-1B visa or E-2 visa or some other kind of work visa to come to the US. Now, there are lots of organizations, crooks, and swindlers that are advertising EB3. They have fake employers, or they have some kind of schemes. They're paying employers to provide information. I mean, potential employers, some kind of the bogus businesses in the U.S. who are making money out of immigrants, paying them to start this EB3 process without really having a real job offer or employment in the U.S. Don't do it. Don't waste your money. Don't waste your time and efforts on working with those firms, because you're going to lose. And eventually, a lot of these organizations eventually get caught, and all of those individuals that received somehow their immigrant visas through this process, they also get reconsidered, and their immigrant visas, their green cards, get revoked. So, again, for EB through employment-based permanent residency, the first step is to find a real employer. And I'm saying a real employer, the actual business company who is willing to sponsor you and they want you to work for them. All right, the next question. Hello, sir. I have pending asylum here since 3 months ago, and I want to see if there is a way to help my family, mother and brothers to come here. I think I have a very strong case. So, if you have a pending asylum case and you think that you have a strong case, there is no process for you to sponsor your mother and brother until, again, you become a U.S. citizen. Then you can sponsor your mother. But, that's once you get asylum, which nobody knows when you're going to have your interview, then you have after asylum, another year to wait for your green card application, and then another 2 years or so until you get your green card, then another 4 years until you can apply for citizenship. So that's not an option. But you can help your mother and brother as a sponsor in the U.S., and if they can come to Mexico, and if they have basis for asylum, if they also have, again, I want to emphasize the coming through Mexico and applying through CBP-1 app to enter the U.S. is a temporary solution to bring your family members here to the U.S. as soon as possible, but they do have to appear in immigration court, and they do have to have basis for asylum. So if they have a danger there, if they have basis for asylum, if they can arrive in Mexico, go through the lawful process of downloading the CBP-1 app, of registering an appointment with the CBP-1 officer, then that would be the best option, best bet. Now, there is also humanitarian parole. You can file for them in the U.S. It takes, currently about 9 months or so until the USCIS responds, and they flatly deny most of the humanitarian parole applications, unfortunately. It's almost like forcing all of these beneficiaries to come through Mexico, which is a dumb strategy for the Biden administration. On one hand, they're trying to streamline the process to make it less dangerous, but on the other hand, they are denying, humanitarian paroles. I mean, I had an individual who consulted with me the day before yesterday who is from Afghanistan. He helped the U.S. Army. He got SIV, which is called Special Immigrant Visa, because he worked with the U.S. Army as interpreter. He was threatened in Afghanistan, and then he fled to the U.S., got this SIV. Now he's a U.S. citizen. Now in Afghanistan, his father was tortured and killed, and his mother and his brother and his sister are stuck there. So his family is being targeted by Taliban. As you all know, Taliban now took over the government in Afghanistan. This guy filed for humanitarian parole with the USCIS, and the USCIS just brutally denied his humanitarian parole. And they don't provide any reasons. They just say that we look at case by case, and your case was denied. Voila, that's it. So this is just ridiculous. I mean, the humanitarian parole would have, if this humanitarian parole was approved, his sister and mother could have went to the U.S. consulate abroad, got a boarding pass. Boarding was called boarding foil, and they could come to the U.S. under that humanitarian parole because of this imminent danger to these Afghan individuals who are immediate family members, I mean, sister and the mother of U.S. citizen who is in the United States because we went there to Afghanistan and because, he helped the U.S. Army. And now we withdrew chaotically from Afghanistan. Now his father was tortured and killed, and his now sister and mother are being threatened. And this government, the USCIS, is denying humanitarian parole. It's just, I don't know what this dumb strategy they have in their mind, but every humanitarian parole to everyone at the border, southern border, is being granted with no questions whatsoever, as long as you download this CBP-1 app. But when someone like this with such a strong case gets denied, it's just, I don't know, boils my blood. But yeah, so you could apply for humanitarian parole, but it's just ridiculously long and difficult, and less likely than having them come to the U.S. border in Mexico and downloading this app and coming to the U.S. Next question I have, well, the same individuals, is that I'm from Syria and my family is in Idlib. I understand, and it's very unfortunate. I feel for you. As I said, if you can get them from Syria to some other country, to Jordan, Lebanon, and then, get them somehow fly to Mexico, download the CBP-1 app and help them come to the United States. They can lawfully enter the U.S. And, being from Syria and being in Idlib and having you as a family member here in the U.S. with a pending asylum, I'm sure they have basis for asylum. I mean, at least they have basis for reasonable fear in Syria. Anybody in Syria does have a reasonable fear for their life and well-being. So again, please press like and subscribe to our channel. Again, I'll answer again as much as questions as possible. Please post your questions in the chat section. I see many other viewers joined. Please press like. That helps us a lot. And if you subscribe to our channel, you will also receive the notices of the future live streams. Okay, so next question I have is telling stories to USCIS or BIA or judge why you need asylum is going to happen to anyone who will apply asylum as from May 11, 2023 inside US. Again, that's from the same individual. I don't understand exactly your question. Starting from May 11, 2023, they changed the Title 42 is removed. Now, there is no specific procedure set in place to conduct asylum interviews at the U.S. border. There are proposals about that, but right now the process is the same. You come through the border, whether it's CBP-1 app or you just come to the checkpoint and you ask for asylum. Most likely you're not going to be detained because they don't have much detention space anymore. And the Biden administration's policy is not to waste all the taxpayer money on detaining families and individuals unless there is some kind of specific indication of potential threat or something from the individual, or they come from the areas, could be young male coming, for example, from Russia. Then they might be detained because there is a potential of Russia sending spies to the U.S. In the current situation. But other than that, no, you'll be processed, you'll be allowed to enter the U.S., then you can apply for asylum in the U.S., and your case will be considered by an immigration judge. Now, they did come up with a pilot process for USCIS to review asylum applications. That has been announced actually from May of last year, but I haven't seen a single case. And we get hundreds of cases since that time, and none of the cases they did actually interview the applicants by the USCIS. Sometimes they issue a notice to appear in immigration court, but the immigration court never receives the file and the case gets stuck. We file for asylum affirmatively with the USCIS, and we always hope that possibly USCIS is going to schedule an interview and they'll interview this individual applicant before the case gets opened in immigration court. But most of the time it's futile. The immigration court eventually gets the file from Immigration and Customs Enforcement, opens it, and then the USCIS has to terminate and forward the case to the court. But the case still needs to be filed. The asylum application still needs to be filed within 1 year, even if the immigration court case is not opened. Okay, I hope this answered your question. All right, the next question is, again, I see new people joining. Thank you so much for viewing. I will answer as many we've started. It's been almost 1 hour that I've been going through explanation of the diversity visa process after being selected, and then I've explained about the ending of Title 42. You all probably heard something in the news about Title 42 being ending today, as of today, which is the official end date of the pandemic emergency. What it means is that individuals can now come into the border and apply for asylum, and they cannot be turned around without having their cases considered. And then I also spoke about family reunification. Now I'm in the process of answering as many questions as I can. Please press like and please subscribe to our channel, and please post your questions. I see many more people joining. Please do post your questions. I will be answering as much as I can. So I'll go on and answer next 2 questions, but I will then give another 2 minutes, 3 minutes or so. If there are no more questions, then we will end the stream. So the next question I have is, my lawyer missed my first court hearing but came for the second hearing in immigration court. The judge said the decision of my case will be in 2025. Please, is this normal? So when you say the decision is going to be in the 2025, I guess what your misunderstanding is that it will be the main hearing, the trial date in 2025. And it is normal, unfortunately, for some judges because their calendars are overbooked and they have, individual hearings lined up, and the earliest date they may have is 2025 for your trial date, for your main, what's called individual hearing in removal proceedings in immigration court. But the immigration courts, as I said, have now hired lots of new judges. And, in some jurisdictions, for example, here in Virginia, they have split the immigration court in Arlington into 2. Now there is Annandale and Sterling Immigration Court, and there is also a spin and is still Baltimore Immigration Court that is also has more judges added to them. So the immigration courts are now trying to balance out the caseload between the judges, and we do get a lot of cases where the judges change. So they move one. The case of our client from one judge to another, and they advance the individual hearings. So just because it's scheduled for 2025, it doesn't mean necessarily that it will be in 2025. There is a good chance that you will get a notice that your hearing is going to be much sooner than that. Now, if you do want your main hearing, your individual hearing, your asylum case to be sooner than 2025, you and your lawyer can also file a motion to advance your hearing. And many people, including lawyers, many applicants and lawyers, they neglect this. If you file a motion to advance with an immigration judge, it does get frequently granted. I mean, it gets granted almost all the time, but does the judge have a new date that they can give you, an opening? That's the question. And most of the time they do, because the reality is that these immigration courts, cases in immigration courts a lot of times end sooner. Somebody gets married with a U.S. citizen, or somebody moves, or somebody withdraws their case, or the government agrees on what's called prosecutorial discretion to dismiss the removal proceedings before the individual hearing. And now all of a sudden the judge who has individual hearings lined up for the next 3-4 years now suddenly has an opening next week or next month, a window, because some other case got canceled. So your attorney can maneuver with the judge's clerk to make sure that your case gets put on that opening, on that window. And not many applicants want their cases to be heard faster. So work with your lawyer, and there is a good chance you may get your individual hearing moved to much earlier date. Okay. Do you have current EB3 jobs? I can do AOS if you have EB3 jobs now. No, we don't have EB3 jobs. We don't offer jobs. We don't We offer jobs for immigration attorneys and paralegals. So, if you're one of them, we'll be glad to consider, but we don't offer jobs for EB3. You need to find an employer who's willing to sponsor you if you want to apply for EB3. Okay, can I ask for interpreter in asylum case hearing? Yes, you can bring your interpreter for asylum case. Well, when you say hearing, I'm sorry. If it's an interview, yes. If it's a hearing, no. The government is going to give you. So you can ask the government at your master hearing that you need an interpreter, and the court is going to provide you interpreter for your hearing, for your both master hearing and individual hearing. But in master hearing, usually we'll waive the interpreter because then it bogs the system. Then you have to have another hearing when the government pays money and brings an interpreter or gets somebody on the phone. So that becomes, but in the master hearing, there is not much going on, so you don't need an interpreter. But yes, for the individual hearings, for the main hearings, the government must provide an interpreter. All right, next question is, hello, I am from Ethiopia, currently in the USA, came 2 months ago, came to apply for asylum with B1, B2 visitor visa. Is there any other means to stay in the USA, get my work permit other than asylum? Yes, well, there are many ways to change your status, remain in the U.S., and so on. But the question is, do you qualify, right? So, for example, there is an investor visa, right? So if you can, create a business here and invest, substantial amount of money. There is a marriage-based case, but it's not me telling you that there is this, you should do this. If you're not planning to get married, if you don't have a U.S. citizen or permanent resident fiance, then there is no point to talk about those ways. So, that's a good question, because I often get asked by someone who is consulting with me. They start the question with, what are the ways to immigrate to the United States? It's too broad. I mean, if we talk about all the possible ways of immigrating into the U.S., then you're going to be wasting your money. I'm going to be wasting my time and your time. We're going to be talking about different things. Like, for example, there is a religious visa. Should we talk about this? Are you a priest, so that we can talk about this? Or there is a process for talented individuals who have extraordinary abilities. Do you have that? Should we talk about this? So the best idea is, prior to consulting with attorney one-on-one, to ask these questions. Do your research online. Go to our website, I.S.Law Firm.com, and look at all the different immigration categories and see which ones you want to talk about, and then schedule a consultation. Then you're going to be spending your time more productively, asking specific questions about the type of category of visa for which you may qualify. But the other challenge you have is that you came to the U.S. with a B1, B2 visitor visa as you wrote, came to apply for asylum. So you already had a preconceived intent of remaining permanently in the U.S. and applying for asylum. And that's not a problem for asylum case. So it doesn't matter how you entered the U.S. or, whether you had an intent or so on with a B1, B2 visitor visa. That doesn't matter for asylum, but it matters for something else. Let's say if you want to change your status in the U.S. to F1 student visa, student status, you are not going to be able to do so, because you clearly have an immigrant intent, as you mentioned yourself. And, for a student status, you have to demonstrate that you don't have immigrant intent, meaning you don't have an intent of permanently remaining in the United States. Second question, I'm planning to apply for asylum in Minnesota. Is this good state for asylum? I read 2023 work permit takes only 30 days after filing asylum. Please tell me more about this. Well, there is no such a thing as a good state or bad state. I mean, I've personally been in an asylum office in Minnesota for in-person interviews. I've really liked the officer, and I got approvals for cases that I've handled there. Now, it doesn't matter. I mean, it's not, there are so many different factors. So, you have to apply for asylum wherever you are. And if you move to another state, then you can change your asylum office. You can, your asylum office is going to change. You'll have to notify. The work permit doesn't take 30 days after filing for asylum. After filing for asylum, you have to wait 150 days, then apply for work permit. And that takes 30 days after applying for work permit, not for asylum. So realistically, you're going to get your work permit 6 months after your asylum application is filed. I meant my green card. I am a green card holder. Can I still renew my visa or apply for citizenship? Oh, okay, I kind of jumped. So this individual was asking, I was arrested for domestic violence assault for misdemeanor. My charges were dropped and I was released without having any court. Can I still travel outside of the country and be able to come back? I meant my green card. I am a green card holder. Yes, you can travel. My recommendation is get certified records, disposition records from courts or court where you had this domestic violence assault charge, and carry it with you. Anytime you travel outside of the US, you have to have that document with you, because at the border you will be always questioned and you may be processed. They may be looking into the system to see what happened to this. So carry these. Basically, bottom line again is get certified records of this, disposition records of these charges, and carry it with you until you become a citizen. Now you have to also provide all those certified records to the USCIS when you apply for citizenship. That's another thing you have to do. So get it and then carry with you and use it to apply for citizenship. But since your cases were dropped, you were not found guilty, there's nothing for you to worry about. You have to disclose that you were arrested and charged, but it's been dropped, so you're not guilty, and you're not guilty until proven so. All right, next question is, I'm a US citizen. Can I file for my brother and sister who both reside in Africa? How long does it take? I can sponsor them. Yes, as I said, you can file for your brother and sister. It's going to take about 16 years plus of wait time, and there's nothing you can do about it. The Congress will have to change the law to make it faster. But other than that, there is nothing you can do to expedite this process. It will take about 16 plus years. And during that time, they can be also presumed to have immigrant intent, which means they may not be eligible for a visitor visa or student visa during that time. So, be careful if you do want to file it, in the hopes that after 16 years they'll move to the US. But during that time, you may be actually closing the doors on them from being able to obtain visitor visa to visit you here in the US. All right, next question, sir. Can I apply for EB3 visa? I have pending asylum, but the immigration received my file after my visit. Visa expired just one day because the status of the weather. FedEx delivered it late. Yes, it's very much possible. You may be eligible for EB3 visa. Now, this is a very delicate situation, because the USCIS in the past was more willing to approve the adjustment of status for those individuals who had a pending asylum case, and while they applied during status. Now, this one-day thing that can be cured, I don't think that's the biggest problem. But now the USCIS has taken a position that if your status expired, even while you were waiting for asylum, you are out of status. That means you cannot adjust status in the US. So many of my colleagues report that the cases they filed with that hope are being denied. But it can be processed. Your case specifically can be processed through consulate. And we have done this, and we still do that. We get advanced parole, so you don't lose your pending asylum case, and we'll let you travel to the US consulate abroad to get your immigrant visa based on EB3 to re-enter the US. Contact our office. There is a contact information there. Schedule a consultation. It will be worth it. So you will be able to answer all of your questions directly, and will get all direct answers as to what and how this can be done. All right, I'm from Pakistan. I want to seek asylum due to threats made by the army to our family. I'm currently in the US on F1 visa, and the situation in Pakistan has changed. What do I do? What you do is you apply for asylum. So you need to prepare and file your asylum application. You need to be very thorough and detailed when filing it. Don't just file the bare bones application without supporting documentation. You have to have a very detailed declaration, explanation, the country reports, and evidence. All of that needs to be very thoroughly and properly prepared and filed. If you don't, then this will significantly reduce the chances and damage your case, because if you file incomplete application, first, it's going to take many years. Number two, the USCIS is going to criticize and look down upon your case, because a lot of times people file just an application to get by, to be able to lawfully remain in the US, get work permit, and then they start developing stories and making things up. And that's the impression that the USCIS officer is going to get from your application. So make sure you start it properly, do it properly. Contact us, schedule a consultation to discuss your case, and we'll tell you what we can do and how we can make sure to maximize your chances of grant of asylum. All right. Thank you very much, sir. Thank you. Thank you for asking questions. How much do you charge to file for asylum case for a person with legal status in the U.S.? There is no standard fee. It's case by case. There are many circumstances that affect, depends whether the asylum is filed in immigration court, an immigration office, the location, the type of the case, individuals involved. So there is no specific standard fee that I can quote you here. Especially asylum cases, it just varies so much. It will give you wrong impression if I give you a huge range of the possible fees. Hey, I'm planning to come LA and going to apply for asylum, but I couldn't find accommodation. So is there any help from government or any private chargeable accommodation available? The US government doesn't provide accommodation or anything until you are granted asylum. Even if you do, it's limited. The US is not a social kind of, it's not a country for social benefits, social support compared to many others, like in Europe or Canada, for example. You get a lot of more social benefits. But state by state, there are more, states providing more social benefits and so on for immigrants, non-immigrants, for anybody. So it depends on the state you are. I mean, LA, I assume, doesn't refer to Louisiana, which is the abbreviation for the state of Louisiana. If it is so, then you're going to be much more limited there in terms of social benefits. But I assume that means Los Angeles, California, then, you're in luck. You got a lot, as many would say, a socialist state within United States. Thank you so much. You're welcome. How would you help in LA if I want to visit you for my case? We can help you with everything. It's just same way as if we were there. There is no need to come in person to our office at any point throughout the process. So what we do is when we take the case, we prepare all of the forms on your behalf. We gather all of the documents with you. We put the package together on your behalf. We prepare your declaration with you together. We file the package on your behalf with the government. We receive all your notices on your behalf. We communicate with the government on your behalf. And when your interview is scheduled, or if your hearing is scheduled, then I attend those interviews and hearings with you. As I said, they're all done remotely now, so there is no need to limit yourself to your locality or to have me fly to wherever your case is going to be. So we handle the process from the beginning to the end. We hold your hand and walk through it with you from the beginning to the end. Folks, I will try to answer the remaining questions. Again, thank you so much for joining. Please press like, please share this video in your channels or in your social media, and please subscribe to our channel. So let me answer as much as I can, and I have to go because I have a call that is already delayed. Hello, I filed asylum-based green card, and my BIA reopening is also pending. Okay, okay, let's just do. Okay, I don't see the question here. All right, good. Next question. Please give me answer my daughter priority date. Okay, I was just told by the admin that I also need to announce that it's going to be again at 12. Well, how about we actually try 12:30 noon, because it seems like everybody was able to join at 12:30. So next Thursday, we will do another live session at 12:30. We'll schedule it for 12:30 Eastern Time, Washington, D.C., New York time at 12:30 next Thursday. Please join us again and ask any questions you have. Okay. All right, let me ask this question. Can I file asylum-based green card while BIA reopening and terminate old removal order is pending? No, if the BIA has your case, you have to get the BIA reopen the case, and then you can file your asylum application. But I assume your case is in BIA because of the previous asylum denial or order of removal. The bottom line is these are very complicated processes for you to try to handle it on your own. Consult with a lawyer in person. It's very also fact-specific questions. So the lawyer needs to know all of the details of your case. If you have an attorney, consult with them. If you don't, then look for one. If you want us to handle it, we'll be happy to help you. You can contact us. There is contact information here, and we'll be able to help you as much as we can. My priority date is June 2008. How long will that take? I don't know. Oh, that's for applying for daughter. So somebody filed for daughter June 2008. As I said, well, I mean, for daughter, it depends. If your daughter is married, over 21, it may be around now. But look at the visa bulletin. So the State Department published the visa bulletin, and you will see the exact priority date. And you can look and see how fast it's been moving to have an estimate of how long it will take. All right. Thank you so much, sir. Thank you. You're welcome. Thank you for joining us. Hello, sir. What does it mean to have RFE for medical immediately after filing? So that's a very good question, and this will be the last question I'll answer again. Join us next Thursday at 12:30 Eastern Time, Washington, D.C., or also New York time at 12:30 for the next session, and you can ask as many questions as you have. Please press like and please subscribe to our channel. And thank you so much for viewing this live session. But I'll answer this question because that's very important. The USCIS started recently sending notices to all of the adjustment of status applicants about the medical examination. But it's been very grossly mishandled because they don't indicate even the A number or the case number or name of the applicant, and they send it to everybody indiscriminately, even if you filed your medical examination report. So we always recommend filing medical examination report together with your adjustment of status, because not just medical examination, but as much evidence as possible to avoid the RFEs, to avoid having the USCIS schedule interviews. Because the USCIS is trying to avoid scheduling interviews, they're trying to streamline the process, and they try to approve the cases based on paper. To do so, they're sending this notice, which basically says that if you haven't filed your medical exam, file it now as a response to this notice. But if you filed your medical exam report together with your adjustment of status and you still got no notice, don't be alarmed, don't panic. They have your medical exam, but it's just this thing is being mishandled. They're sending it to everybody, even if you had filed your medical exam. But if you got an RFE, which is a separate thing than this notice, RFE, which basically says request for evidence, and specifically it has your case number, name, and all that, and the officer who's sending it to you, it asks for your medical exam report. There may be two things. Either you didn't file your medical exam report on time when you filed your package. Don't be alarmed that this RFE basically says file it now. There basically means it's good news. It means basically they're getting ready to approve your case, but the only thing missing is the medical exam. Or the second thing, that you may have filed your medical exam report previously, but there was some kind of expiration, some kind of defect, or the expiration of the form was expired before you filed, or something went wrong, But typically that's not the case. Typically what it means is that you didn't file your I-693 medical examination report together with your adjustment of status, which this RFE now gives you a chance to do. And that also means that they're not scheduling an interview. They'll approve your case without an interview. Again, thank you so much for joining us. Thank you so much for viewing, for all these very good questions that you posted. Please join us next Thursday at 12:30. We'll make an announcement, and I'll briefly talk about some topic and then answer as many questions as I can. Again, please press like and subscribe to our channel. I'd greatly appreciate that. Thank you and have a nice day. Bye-bye.